Initially, police prosecutors were prosecuting in all courts. When we took over, we professionalized prosecution. We no longer have police prosecutors in our courtrooms. This is being done by Prosecution Council. Other than that, when Mr. Haji took over the helm of the Director of Public Prosecutions, he found when we had an initiative where we were looking at the position or the contribution of the criminal justice sector to the development of this country, and how the Department of Public Prosecutions or the Office of the Director of Public Prosecution was assisting or impeding the realization of the objectives of this country. I therefore, together with others, started an initiative called All for Justice. And All for Justice, we wanted to look at the role the prosecution is playing in realizing the objectives of the criminal justice sector. We visited almost all the prisons in Kenya. We interviewed about 20,000 prisoners. And Honorable Speaker and members, I really wonder what led us to do this, because looking back, I realized that somebody was directing my steps. Because the conclusion of that report, which I have here today, indicated that what the prosecution wanted to do could not be done by the prosecution, but could only be done by the Attorney General. And I want to run over 4 of them. When we went through the 20,000 inmates, pretrial inmates, and we checked all the prisons in Kenya, it was a wonder that although under the Constitution we talk about innocent unless proven guilty, it was clear that our criminal justice system is inconsistent with the right of innocence until proven guilty. Why do I say that? We found that most of the people who were in custody for petty offenses. There was nothing we could do because the law provided for them. Then we realized that there is a need for us to relook at our offenses in Kenya so that we can decriminalize petty offenses. At the same time, there is a need for us to find a different way of dealing with petty offenses. So we made that recommendation to the Office of the Attorney General. We also found that most of the people who were in custody were young people and they were poor. There was no mechanism that these people could be assisted. Each time they went to court, they needed bail, and bail is in cash. So we asked ourselves, is cash the only way that we can secure the attendance of accused persons to court? We made the recommendation to the NCAJ, and we're waiting for the Attorney General to attend to it. Thirdly, we also found that most of the people who were in custody were not represented. There was no equality of arms. They could not defend themselves. We made a recommendation to the Attorney General that there was a need to operationalize the legal aid services. Because when people are not represented, they are not able to move through the system. And honorable members and Mr. Speaker, sir, I would invite you people to visit our pretrial detentions. We talk about rights. We talk about the rights of the arrested, the rights of the accused persons, the rights of the detained person, but we have not made it tangible. Because if you visit these institutions, you will wonder what we are as Kenya. None of the people charged with corruption of cases was in pretrial detention. It is only the poor. They have no food, they have no classes, cases take very long, and most people who should be in custody are working outside. And most people who should be outside are in custody. There is a need for us to reform the criminal justice sector. We also observed that cases were taking very long, and there was a need for us to expedite those cases through the system. As a result of that, DPP Haji, myself and the office tried to come up with initiatives within our power. And that is why we came up with the decision to charge guidelines. The decision to, and that is one of my biggest achievement, our biggest achievement, the decision to charge guidelines is supposed to regulate how we make the decision to charge, so that we sieve the system, petty cases do not go to court. We also came up with the diversion guidelines, and the diversion guidelines is supposed to attend to alternatives to prosecutions, because we realize that not everybody who is charged with an offense should go through the system. And that was said by Sir Shawcross, the Attorney General of England in 1950, that not in all cases where you have evidence, people should go through court. So we came up with a diversion guideline to assist us to sieve the cases. What is the challenge that the DPP could not deal with that the Attorney General should deal with? A prosecutor could decide to divert, but where are the structures to divert to? Because if I have young people who have been brought to me and I realize that they can be rehabilitated, I need a rehabilitation center. I need counseling services. How many of our counties have rehabilitation centers and have counseling facilities? Therefore, our action is in futility. Prosecutors are being accused of taking many cases to court. It is because we have initiatives, but we need other structures of government to assist us to realize those initiatives.
Could wind up on that?
Yes. And we also found that most of our prosecutors had no capacity, and therefore maybe we're making wrong decisions. And that is the reason why, in order to harness and structure the training of prosecutors, we came up with the Prosecution Training Institute. At the Prosecution Training Institute, we now have a fully fledged course where prosecutors can undertake continuous legal training, specialized training, and also training on emerging crimes. We hope that the Prosecution Training Institute will be a center for the region and will bring A&A to this country. On access to justice, we found that prosecutors were having a difficulty in attending court. We therefore digitized. We have Wadilifu. Most processes within the office of the DPP are digitized. In order to enhance access to justice, we, together with the EU, got a boat to help us to attend to courts that are outside the normal courts, that is in Lamu. And it is also pursuant to that initiative that we came up with community initiatives where we would go to the community and have community dialogues so that we can tell them about their rights and the criminal justice sector. And it is also pursuant to that we did another research on traffic to find why it is impacting the criminal justice sector. We find that it is clogging the criminal justice sector. Most of the crimes that we arrest people for are non-moving and they are petty, like not wearing a uniform and touting. And it is for that reason that the Director of Public Prosecutions directed that touting should not be charged so that we don't clog the system. I have put all that before you.
Yes. And
at an appropriate time, if I'm nominated, I intend to use...
You've been nominated. If you are found suitable.
If I am found suitable, Honorable Speaker, sir, and members, this experience will help me to oversee and to steer the office of the Attorney General. Thank you.
Ichungwa, Majority Leader.
Thank you, Honorable Speaker. Honorable Speaker, allow me to also say I know the nominee. I have worked with her when I was the Vice Chair of the Public Investments Committee when she was in the Attorney General Chambers. And Honorable Speaker, maybe to start with, her name Agik, I'm told, means I have arrived. Is that so?
That is correct, sir.
So, having started your career at the Attorney General's Chambers as a State Counsel, probably you have arrived as AG nominee. But we just changed the law for the Attorney General Act, I think about 3 or 4 months ago. And we now gave the AG power to recruit you and appoint your own State Counsel. Unlike before where you had to go through the Public Service Commission. One, I would like to hear your view on whether that was a good thing to do, or if you feel probably those powers should have been left because there was a tussle between the office of the AG and the Public Service Commission. the Public Service Commission insisting that they should continue appointing or rather recruiting staff and across the entire public service. I would just want to hear your view on that, whether it is good to have those powers in the AG or whether that should be reviewed to take the powers back for recruitment back to the Public Service Commission. Two, I'd want to hear if, since this is a law now, and government has lost quite a number of cases, largely on account of the caliber of staff that are there in the Attorney General's chambers in terms of the State Council. Many do not turn up in court, and many cases are lost in court. That has occasioned government losing many cases in court, and some that are very costly to taxpayers. I think if you were to accumulate the total number of judgments against government in terms of quantum of amounts that ought to be paid by government, they would run into the trillions. I would want to hear what is it that you intend to do should you be approved. One, to make sure that you are able to recruit and retain good state counsel, because the Attorney General Chambers also has become a training ground for counsel. They come there, train for a few years, and they are poached by Parliament, they are poached by ministries and other organizations. What will you do to retain good state counsel so that government doesn't continue losing cases in court?
Go ahead, answer those two.
Thank you, Honorable Speaker, sir, and members. With regard to delinking, I am the wrong person to ask, because I fully support this. And this is what has helped the Office of the Director of Public Prosecutions. When we were delinked from the Office of the Attorney General, the ODPP Act, the Office of the Director of Public Prosecutions Act, which operationalized Article 157 of the Constitution, provided for a board, which is chaired by the DPP, and the mandate of this board is to advise the DPP on recruitment discipline of counsel. Why this is a good idea, it gave us the opportunity of relooking at our establishment so that we could get the necessary skills and the requisite officers to propel the Office of the Director of Public Prosecutions. I am the secretary to that board, and I know what we have achieved. We have increased our establishment. We have been able to rationalize our staff. We have been able to negotiate for our staff. As we speak today, it is the Office of the DPP that negotiated with SRC to allow lawyers in government to earn what we call in the ODPP prosecution allowance, and in the Office of the Attorney General it's called another allowance, which is different from non-practicing allowance, and this is to help retain officers. At the same time, it is within that board, which I serve as a secretary, that we were able to find ways of complying with the Constitution. We therefore rationalize staff. If you go to the Office of the Director of Public Prosecutions today, we have 60% women, 40% men. It is the face of Kenya. We have tried to recruit from every part of this country. Secondly, the board has also helped us with issues of discipline because they go quickly and we are able to conclude them within time. Third, the board has assisted because the DPP is required on any other matter to consult the board. So necessarily when it warrants, we go back to the board to get counsel on issues of human resource. And it is through that we have relooked at our human resource manuals, we have looked at our transfer policy, we have also relooked at our work environment. And the beauty of the board is that the PS Treasury is represented. That is at the ODPP's office. The PS Treasury is represented. The Attorney General is represented. The Judiciary is represented. The Kenya Police is represented. The Law Society is represented. So there is collegiality. And we are able to share our expertise and experience on how we can work together as a chain. The second question was a comment on government losing cases and what I would do. Mr. Speaker, sir, and members, there are reasons why people lose cases, not only the government. All of us lose cases one time or another for maybe these 3 reasons. 1, it could be that you have a bad case. You will lose it. It could be that you have bad representation or inadequate representation. You could do that. You could also lose a case because the court has erred. In which case, if you feel aggrieved, you will go back to court, either for appeal or revision. You could also lose a case for any other reason. Any other reason? None of the above. So what I would do, if I'm losing a case because I have a bad case, it would be my responsibility as the Attorney General to make sure that before we go to court, I relook at the cases that we have. I try to mitigate the risk of going to court. And if possible, if I have a bad case, try to find other mechanisms of resolving the issue without going to court and incurring expenses to the government. And going forward, I would also say that it will be the responsibility of the Attorney General to advise ministries and MDAs on how they should deal with court matters such that the Attorney General is involved from the beginning. That is if I have a bad case. If I have inadequate or insufficient representation, I'll look at my capacity and the expertise that I have within the Office of the Attorney General. And this is exactly what we did in the Office of the DPP, because initially we had private counsel assisting us, but with the time, we relooked at the capacities that we have. We have to enhance the capacity of our state counsel, not only legally, but also their working environment and their terms and conditions of service. And we would also want to make sure that there is continuity and succession within the Office of the Attorney General. If I lose a case because the court has erred, I will go back to court on appeal on those issues. I may also go back to court on revision on issues that I think warrant revision. So going forward, if I am confirmed to this position, I will make sure that if I have a bad case, I look for mitigating factors, I do a risk assessment so that I protect the government. If I have insufficient or inadequate representation, I will make sure that wherever the government is to be defended in court, we have the correct people defending the government, we put our foot forward, and we act in the interest of justice. If I lose a case for any other reason, I have recourse to go to the JSC. Thank you.
Jeanette.
Thank you, Mr. Speaker. Mr. Speaker, Madam Nominee, in this vetting, we are looking at your suitability for the job and your competence for the job. Now, I want to ask you this question. One, you have attempted multiple times to become a judge in the Court of Appeal, or once maybe, and despite your impeccable academic credentials and illustrious legal career, you have been bypassed each time. Did JSC provide you with answers as to why they did that? Or was it your last name? What could be the problem? Can you explain to us as a committee what could be the problem? My second question is, it's on record. This country went through post-election violence in 2007, 2008. And you're on record, you say that much later, that there is no evidence to charge certain people who are involved in that post-election violence. What has made you make that decision? Can you explain to the committee why you took that decision as a serious prosecutor, a distinguished prosecutor who is known for prosecuting people? Why did you take that decision? And my last one is, there are bills that have passed through this House that have been declared unconstitutional by the court. And some of these bills emanated from the executive with the participation of the Office of the Attorney General. What will you do to improve the quality of legislation coming from the executive now that if you are approved, you'll become the Attorney General? so that the issues of courts declaring laws enacted by Parliament as a constitution becomes a thing of the past? I have those 3 questions as of now. Thank you.
Dorcas, answer them quickly.
Thank you, sir. About the JSC, I think the positions were few. I'm not the only one who succeeded, but I believe that it was not my time, and my time was going to...
Do they give reasons when they don't give you the job? They don't?
They don't, sir.
Okay.
They don't. About post-election violence, and me having said that there was no reason to prosecute, I want to say that I chaired a task force 3 years down the line to look at offenses that were committed subsequent to the post-election violence. The task force concluded a report that was presented to His Excellency the President, and after it was presented to the President, it was then presented to different arms of government to deal with the recommendations. But as far as prosecution is concerned, I chaired that task force as a prosecutor also, and I was expected to look at the evidence with the lens of a prosecutor, which requires me to be sure that before I can recommend prosecution, I have sufficient evidence and it is in the public interest, and I have a reasonable prospect of conviction. I used the law as it was, and I applied it to the circumstances, and I did my contribution to the task force, and whatever was presented to His Excellency the President was the result of the conclusion of the task force. That task force included civil society. Thank you. About bills going to Parliament and the government losing or courts declaring bills or legislation unconstitutional. First and foremost, it is the work of the courts to do that. That is one of the duties that they've been given. And if they do it, they are not doing a wrong thing. We should ask ourselves, why then the notoriety? I believe that most legislations that we have come up with of late have been to comply or to operationalize the 2010 constitutions. Most of the contents of those bills contain new jurisprudence, not only to the executive, but even to the judiciary. I take it as a testing time. We are testing the Constitution through bills, through legislation. Honorable Speaker and honorable members, a testament to this is that even in the Court of Appeal, there are issues that they've not agreed on. They have not given direction. It is a good thing for us to test a new legislation. It will be volatile for some time, but after some times when we have matured with the 2010 Constitution, then the law will be settled. But that having been said, it is a concern if bills are declared unconstitutional when the Honorable Attorney General has contributed to them. What I would do is to find out why they have been declared unconstitutional. Number 2, I would make sure that as the Attorney General, I advise that wherever we come up with a bill, it meets the constitutional requirements as provided. Thank you.
Now, Dorcas nominee will take a batch of 333, starting with Isola, Posing, then on Gikaria, in that order.
All right, thank you.
One question each. No preambles.
Okay, please allow me to ask two. Chairman, no preamble. You have served in the AG's office before. Are there instances where the AG then advised the executive and the advice was not taken? What will you do if this committee finds you suitable in the National Assembly and you advise the executive on different matters and your advice is not taken? The second question is that there are areas or there are circumstances where cases have been lost in court, as you have said. But then the judiciary then orders compensation to the litigants. My question is, why should taxpayers carry the burden of the compensation while there is an officer in the executive whose decisions have occasioned the judiciary asking that that money should be compensated? And we have many litigants who've never been compensated that the judiciary asked that they get compensated. And lastly, the 2/3 gender rule. How will you make sure it is realized? We cannot selectively follow the Constitution on the matters that suit us, but on matters 2/3 we don't. I will not speak again later, so there's someone who has asked a question from the public, that in Kenya today, the holder of a law degree is not eligible for admission to the role of advocates unless they attend the advocates training program and pass their bar exams. Currently, ATP is only offered at the Kenya School of Law. And so there have been attempts to review the law that mandates this. And so there is and the attempts have been received with different divergent legal view. What is your position on this?
Thank you, Chairman. Mine to the nominee, the Office of Attorney General, is practical one, which is, nominee, I want to know, the people of Kenya, in assessing your suitability, we want to know, what is your opinion or vision on these contracts or clauses in contracts that a government entity enters with international companies, and in those clauses, the clauses inside those contracts, and I've seen it from being chairman PIC, where Kenya lose money, they put a clause to say that if there's a conflict in that contract, that the arbitration or the legal resolution will be done, for example, in London. And yet, Madam Nominee, through the chairman, the money is paid is 100% exchequer, which means it's our money. And our case in point is GDC, where Kenya lost hundreds of millions of money in London through something I call kangaroo court called arbitration, where people can agree to fleece people's money and agree. Arbitrations are legitimate courts within both our system and the international systems. They cannot be called kangaroo courts. That's not a fair comment. I thank you, Honorable Speaker, but that's my opinion. Maybe it's different from the legal practice, but I found it a kangaroo court, Honorable Speaker, that just people sit down and agree. And Kenyans, Madam Nominee, through my speaker, has lost a lot of money through that process. So what's your opinion? Can we change the law and have a contract, particularly where Kenyan money, which is exchequer, maybe if it's a loan, that's a different way. What is your opinion on that, Madam Nominee, so that Kenyans don't lose money as we lost through GDC? I thank you, Speaker, in that kangaroo court. Not being a lawyer yourself, we forgive you. Go on, Kikaria.
Thank you, Chairman. Chairman, I have this question.
Yes, Junet.
Speaker, I thought Honorable Koseng is a lawyer. I saw him that time when we had the cases in Hague. I saw him carrying a lot of documents and saying that he's filing cases in Hague, and
that is exactly what he was doing, carrying documents. That doesn't make you a lawyer. Go on, Docas.
Point of order, Speaker. But
go on, sorry, Gikaria.
Chair, there is this review of the Constitution. There is a call for us to review the Constitution, either be it through the parliamentary initiative or the popular initiative, on some quarters, like not having even the opposition leader in parliament and things like that. And also the very thin line between, like what happened just recently, on a constitutional issue under Article 37 and the Public Order Act. Maybe in your view, Madam Nominee, what, in your view, are the sections that we need to look for in terms of the constitutional amendment, particularly to be able to align some of those very thin lines between Article 37 and the Public Order Act, where you have to balance the two for us to realize. So maybe in your view, which areas do we need to look for the amendment in the Constitution? Thank you.
Yes, nominee, can you deal?
Chairman, and my colleagues, my apologies. It has something to do with what I had asked. I just want to know the past costly AG advices to government, mainly driven by vested in-house manipulative cartels, especially in Treasury, and official systems operatives in huge government development projects. I'd like to know your view on that.